In other news, the swearing in of Chief Administrative Secretaries this morning completes the formation of the executive wing of the Kenya Kwanza government. However, their lack of vetting and approval by Parliament has drawn mixed reactions. NTV's Ibrahim Karanja explains.
Hours after National Assembly Speaker Moses Wetangula gave the President the go-ahead to appoint CASs without the House's approval, President William Ruto presided over the swearing-in of the 50 men and women at State House, Nairobi, early Thursday.
You did not make a statement. You took oath. And I expect you to take the oath you have taken this morning with the seriousness it deserves, with the seriousness any solemn oath deserves.
In a communication by State House spokesperson Hussein Mohammed, Wetangula is quoted to have noted the absence of an express constitutional or statutory requirement for Parliament to vet nominees to the position of Chief Administrative Secretaries. As much as Speaker Wetangula is well within the law to make that observation, there is also the issue of a High Court ruling in 2021 that stated that such an appointment of CASs require parliamentary approval. Justice Anthony Mrima, in a petition challenging the legality of CASs then appointed by retired President Uhuru Kenyatta, ruled that the President can only appoint persons to the positions of PSs and CASs upon such persons being shortlisted, interviewed, recommended for nomination for appointment by the PSC, and on approval by the National Assembly. Lawyers now arguing that for such a vetting to occur, there is a requirement to amend the Public Appointments Parliamentary Approvals Act.
Public Appointments, that is Parliamentary Approvals Act, which envisages that any office created under the Constitution or other any written law which requires to be approved by Parliament before appointment must be so done before that approval must be done before that person takes over office. The Chief Administrative Secretary's office is not a creation of the Constitution or any other law. It is merely an establishment by the Public Service Commission. So that as such, in my view, it would not require necessarily to be approved by Parliament. Having said so, if it do not require public approval by Parliament, then in my view again, that office did not even require to go through the procedure of swearing in.
Yet President William Ruto still has a legal hurdle ahead of him, which he temporarily avoided. That is the appointment of 50 individuals as CASs, 27 appointments more than what had been advised by former Head of Public Service Joseph Kenywa. A case challenging this unexplained and unprocedural increase in numbers could not have directions given by the court, as the orders sought were overtaken by events. Justice Hedwig Ongudi of the High Court in Nairobi having her hands tied in the petition by Eliud Matindi.
I, Rael Chebichilelei,
14 human rights organizations have in a joint statement to newsrooms called out the judiciary on the move to officiate the swearing-in of the CASs despite an active court case. The organizations have said that amidst signs of an imperial presidency, the Kenyan judiciary has abandoned its job of protecting Kenyans from impunity and violation of the Constitution of Kenya.
The appointments of 51 CAS or CASs that has no constitutional basis.
Meanwhile, those whose regions have benefited have praised the president. While Thursday's swearing-in of the 50 CASs completes the formation of the Kenya Kwanza government, it certainly opens a discourse that is both political and legal, and one that may have a bearing on the Kenya Kwanza regime, and especially on its commitment to the rule of law. Ibrahim Karanja, NTV in Nairobi.